Mr. McIntosh? We in session in cause number 325-676 and cause number 330-862. Both cases are styled the state of Texas versus Trenton Fabian Boudreaux. We have Mr. Boudreaux present in court. Mr. Boudreaux is represented by attorney Charles McIntosh, who is appearing via Zoom. Mr. Boudreaux, how are you doing? I'm doing fine. Thanks for asking. Mr. McIntosh, how are you doing?
I'm doing well, Judge. Thank you.
Mr. McIntosh, do you have an announcement you'd like to make in Mr. Boudreaux's case?
Yes, Judge. He had a new case that was picked up. I have not been appointed on it yet. I expect that I will be, but I know that it's on today's docket as well, and so would just ask for a chance.
Yeah, you've been appointed on it.
Okay, I would ask for a chance to get the discovery on that case, Judge, and then try to work these out together.
Okay, now, Mr. Boudreaux, I guess was given bond conditions in his previous case, is that correct?
I do not have knowledge either way, Judge.
Yeah, could check his bond condition. You were supposed to get a interlock on your vehicle. You were required to get an interlock device on any vehicle that you own or operate.
No, it wasn't a car.
I'm saying, do you own a car?
No, sir.
Okay, so, what is that thing called? Okay, hold on a minute. Now there's okay. Mr. McIntosh,
Yes, Judge.
I was looking at, it seemed like we gave Mr. Boudreaux some bond conditions on this first case back in March, it was March 3rd of 2020. That's the date on here. You could, could you hand this to him? Those are the bond conditions that we gave you on March 3rd of 2020. You see that? Okay, now we're going to give you some amended bond conditions. Let's see, number 5. Okay, now, Mr. Boudreaux, the court is going to give you some bond conditions in both cases, cause number 325-676 and cause number 330-862. And the bond conditions are as follows. Following arrest and or accusation in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the following additional conditions. Number one, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition? Condition number two, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and the test indicates the presence of drugs or alcohol in the defendant's body, and that's pursuant to the Texas Code of Criminal Procedure, Article 17.44, Section A2 and Section C2. Do you understand that condition? Condition number three, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition? And condition number four, the defendant who has been arrested or accused of any subsequent offense listed under section 49.04 through 4906 of the Texas Penal Code, and that's where your case is because it's a DWI second. And it states that you shall not operate any motor vehicle unless the vehicle is equipped with an interlock device mechanism that makes impractical the operation of the vehicle if ethyl alcohol is detected in the breath of the operator, and said device shall be installed at the defendant's expense with written verification of such installation being submitted to the court on or before the 10th day of arrest. Do you understand that condition? Now, condition number five, the defendant must get a scram device at the defendant's expense with written verification being submitted to the court within 10 days. Do you understand that condition? Okay, and we may be able to give you some information on where to get, or how to get the scram device, okay? It's a device that you will have to put on, and it'll detect drugs, alcohol in your body, okay? Now, Mr. McIntosh.
Yes, Judge.
Want these cases reset?
Yes, Judge, that's all I'm asking for.
Okay, give us a standard reset. Okay, these cases gonna be reset to January 5th of 2022. Mr. McIntosh, your reset will be sent to you. And Mr. Boudreaux, we're gonna give you your copy of your reset here in court, and we will also give you a copy of these bond conditions, all right? Stand on the 4X. You can keep that. Stand on the 4X, and once you get your reset and a copy of these new bond conditions, you'll be free to go.
And then, Judge, I also have another client on the docket today.
Yeah, we have him in court. Just hold on a minute.
Okay.
Here you go. She gonna make a copy of that. This is cause number 329872. The case is style of state of Texas versus Kyler James Thomas. Mr. Thomas, would you please come forward? Your full name is Kyler James Thomas, is that correct? How you doing, Mr. Thomas? You doing fine? I'm doing fine, thanks for asking. Mr. Thomas, you're represented here in your case by your attorney, Mr. Charles McIntosh. Mr. McIntosh is appearing via Zoom. Mr. McIntosh, do you have an announcement that you would like to make in Mr. Thomas's case?
Yes, Your Honor. I've been speaking with the DA's office, and I was able to get an offer this morning. I just need to be able to confer with my client, talk with him about the details of it. So just one more reset, Judge.
Okay, you want to reset on the same day as Mr. Boudreaux's case?
That works for me, Judge.
Okay, so that'll be reset to January 5th of 2022. Mr. Thomas, you're gonna get a copy. Your case is gonna be reset to January 5th of 2022. You're gonna stand on the X in front of our court coordinator. Once you get your reset, you'll be free to go and you have a blessed day. And Mr. McIntosh, your other client is in jail.
Yes, Judge.
And that case will be, his felony case is set today. We'll keep track and see what happens he actually set for punishment sentencing. So we may, if this case is not dispositive, or if the felony cases is not dispositive of this misdemeanor, of these misdemeanor cases, then if you want, we can set it on our jail run docket for Thursday.
I have to be in Hardin County tomorrow, Judge. But I'll stay in contact with the DA's office and see what we can do. We'll work something out.
Okay. All right. So you're free to go and you have a blessed day.
Thank you, Judge. You as well.
Why don't you go get Cisneros?
Next one to your attorney.
This is cause number 329584. The case is style of state of Texas versus Arturo David Beltra Cisneros. Is that your full name?
Yes, sir. Beltran. There's an N on the.
Oh, N is missing.
Yes, sir.
Okay. How are you doing, Mr. Cisneros?
I'm doing well, sir. How are you?
I'm doing fine. Thanks for asking, Mr. Cisneros. You're represented here by your attorney, Mr. Tom Kelly, who is appearing via Zoom. Mr. Kelly, how are you doing?
Good morning, Judge. I'm well. How are you?
I'm doing fine. Thanks for asking. Mr. Kelly, you have an announcement you'd like to make in Mr. Cisneros' case?
Your Honor, we've made a request for the videos in this case, and I believe we're just waiting on them. So,
Waiting on discovery? Okay.
yes, Judge, we may need longer than a normal reset on this, but whatever the court will allow us to get that evidence from the DA's office.
What date? January 5th is, you see, this is November, December, yeah. What about January 5th?
Should be great, Judge.
Okay, yeah, your case is gonna be reset, Mr. Cisneros, to January 5th of 2022. Once you get your reset, you'll be free to go and you have a blessed day. You can stand on the 4X and our court coordinator will give you your reset.
Yes, sir. Thank you.
All right, and Mr. Kelly, is this your only case?
It is, Your Honor.
Okay, you're free to go as well. Your reset will be sent to you. And you have a blessed day.
You as well, Your Honor. Thank you.
Thank you. We're in session in clause number 329874. The case is styled State of Texas versus George Allen Phillips. Your full name, George Allen Phillips?
Yes, sir.
How are you doing, Mr. Phillips?
Good morning, sir.
I'm doing fine. Mr. Phillips, would you please raise your right hand? Mr. Phillips, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Okay, Mr. Phillips, you may put your hand down. Mr. Phillips, you're here represented by your attorney Scott Rennick. Mr. Rennick, how are you doing?
Well, Judge, thank you.
That's good. Mr. Rennick, do you waive a record in Mr. Phillips' case?
We do, Your Honor.
Mr. Phillips, I have before me an information that alleges that on or about March 30th, of 2021, while you were operating a motor vehicle in Jefferson County, Texas, that you committed the Class B misdemeanor offense of driving while intoxicated. Mr. Phillips, do you understand what you've been charged with?
Yes, sir.
And to this charge, Mr. Phillips, how do you plead? Guilty, not guilty, or no contest?
Guilty.
Now, are you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you're guilty?
Yes.
Mr. Phillips, I have before me a document that is titled the misdemeanor admonishments. It is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes.
Okay, now, Mr. Rennick, I see here you had checked off Class B.
Yes.
It's supposed to be the box below that says driving while intoxicated first. Is it all right?
That's
if
not.
I make
yes,
that
apologize.
correction?
It's my mistake. Yes, Judge. It's
Okay.
my mistake. I checked wrong.
Okay. Now, Mr. Phillips, the range of punishment is the same. It's a Class B misdemeanor, okay? And the range of punishment basically, is confinement in jail for at least 72 hours, but not to exceed 180 days, a fine not to exceed $2,000 or both such fine and confinement. Do you understand that? Okay. Now, Mr. Phillips, on page 2 of the same document, there's a set of initials on a line that's next to a box that's checked guilty. Did you place your initials here?
Yes, sir.
On page 3 of the same document, there's a signature above the line that's titled defendant. Is that your signature?
Yes, sir.
And on the next document, which is the trial court certification of defendant's right of appeal, there's do you recognize this document?
Yes.
And is that your signature above the line that's titled defendant?
Yes, sir.
There are 2 boxes that are checked at the top of this document. Now, the first box states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, sir.
The second box states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that?
Yes, sir.
And Mr. Phillips, I also have before me a document that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
Is this your signature above the line that's titled defendant?
Yes, sir.
Now, Mr. Phillips, prior to signing and initialing these documents, did your attorney, Mr. Rennick, go over these documents with you?
Yes, sir.
And did you read it and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
State, I have before me State's Exhibit Number 1. State, you like to offer State's Exhibit Number 1?
Yes, Your Honor.
Any objections, Mr.
No
Rennick?
objection from the defense.
No objection. State's Exhibit Number 1 will be admitted. Mr. Rennick, you have advised that counsel, Mr. Phillips, is there any evidence that he is currently mentally incompetent to stand trial?
Not from the defense, Your Honor.
Mr. Rennick, Mr. Phillips, your attorney, Mr. Rennick, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Phillips, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
And what is that agreement?
A 1-year deferred adjudicated probation, $800 fine, 60 hours community service, DWI education course, drug and alcohol assessment, and ignition interlock.
Okay, Mr. Phillips, let's see. Mr. Phillips, do you have a regular driver's license or do you have a commercial driver's license?
A regular driver's license.
Okay. And Mr. Boyd, what was there a breath test in this case?
It was blood, Your Honor.
Blood? Okay. What was the test results?
It was, I can tell you. Your Honor.
.130, Your Honor, it was blood.
Okay, so you're below the limit, okay. Mr. Phillips, the state is offering that you serve 1 year deferred adjudicated probation. During the 1 year probationary period, you'll be required to pay a fine of $800 plus court costs of $422. The total fine and court cost is $1,222. You will also be required to pay a probation fee of $60 each month, a urinalysis fee of $15 each month. You'll also be required to pay the Jefferson County DWI education class and initial evaluation fee of $125 on the day of the plea. Should a further evaluation be needed, you'll be required to pay an additional $50. Now, your total monthly installments, that is the amount that you would have to pay each month while you're on probation, is $190. Will you be able to pay the $190 each month?
Yes, sir.
You will also be required to perform 60 hours of community service, attend and complete a DWI education class, have a drug and alcohol assessment, and you'll be required to install an interlock device on any vehicle that you own or operate. You will also be required to adhere to the other standard terms and conditions of your probation. Mr. Phillips, do you understand the state's offer?
Yes, sir.
And do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Now, Mr. Phillips, I will follow the plea bargaining agreement. I would defer a finding of guilt and place you on probation for 1 year with the agreement that you've made with the district attorney's office. Now, Mr. Phillips, pursuant to Article 42A 1.8, the court hereby admonishes you that on violation of a condition of deferred adjudicated community supervision, that you, the defendant, may be arrested and detained as provided in Article 42A.751, and you are entitled to a hearing limited to the determination by the court whether the court will proceed with an adjudication of guilt on the original charge, and the court may not proceed with an adjudication of guilt on the original charge if the court finds that the only evidence supporting the alleged violation of a condition of deferred adjudicated probation supervision is the uncorroborated results of a polygraph exam. And the determination to proceed with an adjudication of guilt on the original charge is reviewable in the same manner as a revocation hearing conducted under Article 42A.751D in a case in which adjudication of guilt was not deferred. Now, Mr. Phillips, and pursuant to Article 42A.110, after adjudication of guilt, all proceedings, including assessment of punishment, pronouncement of sentence, granting of community supervision, and your right to appeal continues if adjudication of guilt have not been deferred. And a court assessing punishment after adjudication of guilt, the defendant charged with a, well, that doesn't apply. So, Mr. Phillips, if you successfully complete your probationary period, this case will be dismissed. It would not result in a conviction on your record, and you may qualify for non-disclosure. And you can talk to your attorney about the non-disclosure because he's quite competent on those matters. Now, Mr. Phillips, stand on the X near your attorney. You're going to follow the directions of our court. You're going to follow the directions of our court clerk. And once you finish following those directions, you'll be free to go and you have a blessed day.
Thank you, Judge.
Just have, okay. And Mr. Rennick, this is you on the case?
Yes, Judge.
You're free to go and you have a blessed day. Nice seeing you.
too.
All right, see you later, Mr. Phillips. Have a blessed day. Mr. Bailiff, could you please get, is that Makiba Hager?
See me clear it out.
Is he on? Okay, this is cause number 326834. The case is styled the state of Texas versus Makiba Giovanni Hager Jr. Is that correct?
Yes, sir.
Mr. Hager, how are you doing?
I'm all right.
That's good. Mr. Hager, you're here represented by your attorney, Mr. Langston Adams, who is appearing via Zoom.
Yes,
Mr.
Your Honor, I'm here.
Mr. Adams, how are you doing?
Doing good, Judge.
Okay, Mr. Adams, Mr. Hager's case is on the court's announcement docket. You have an announcement you'd like to make in Mr. Hager's case?
Yes, we do have an offer, and I talked to my client, and he told me he put it on the trial docket.
Okay, just hold on for your trial date.
February 21st.
Okay, this case is going to be reset for trial on February 21st of 2022. Mr. Langston Adams, your reset will be sent to you. I think this will conclude your case. You're free to go and you have a blessed day. And Mr. Haggard, you can get your reset from our court coordinator. Once you get your reset, you'll be free to go and you have a blessed day as well.
All right. Take it easy, Judge. Bye-bye.
All right, same to you. Over here, over there. Okay, we'll be in